morning, and thank you for joining us. We are going to spend some time today talking about extraordinary ability visas and green cards. In particular, we will talk about the O1, the EB1, and the national interest waiver. A few things before we get started. This firm is a full-service immigration firm, but we focus on a number of different types of visas, including visas in the extraordinary ability category. We will continue our webinar series, doing at least 2 webinars a month on different topics. At the end of this webinar, we'll send out a few things. One is the PowerPoint that you see today. Another is an extraordinary ability guide and an NIW guide, and then also a link to where you can sign up for additional webinars. In terms of our panelists today, my name is Kelly LeGrand-Wiener. I'm the managing attorney at Scott Legal and have several years of experience processing extraordinary ability visas. We're also very lucky to have Michaela Vrazdova, who's an associate at Scott Legal and also has several years of experience processing these visas. If you have questions throughout the presentation, please write them into the chat box or the Q&A, and we'll get to them towards the end of the presentation. We will be kind of walking through the topics in the PowerPoint by, having some discussion back and forth between Michaela and I, largely focus on kind of questions we've gotten in the past from other clients. So without further delay, I'm going to, kind of get started by asking Michaela, if I'm somebody who's very accomplished in my field and I want to work in the United States, which extraordinary ability visa is right for me? Can you go over those options?
Yeah, so good morning, everyone. So there are basically 3 options for people who have extraordinary ability in their field. So 2 options are non-immigrant visa options, and then the third option is a green card option. So the O1A visa and O1B visa are the non-immigrant visa options, and this means that if you will get this visa, you can stay in the US for up to 3 years, but after the 3-year period, you will either have to renew the visa or you will need to leave the US. And the EB1A green card option is a green card, and this means that once you get this green card, you will usually get it for 10 years, and then you can kind of keep renewing it indefinitely. And this will give you an option to stay in the US basically indefinitely. So let's go over these 3 options in more detail. So the O1A visa is a non-immigrant visa for people who have extraordinary ability in the field of science, education, business, or athletics. And so who can qualify for an O1A visa? So not everyone can qualify, and the standard is that the person who wants to apply for an O1A visa must be one of the small percentage of people in the field, and this person must have arisen to the very top of their specific field. The O1B visa is also a non-immigrant visa for individuals who have extraordinary ability in the field of arts or that have extraordinary achievement in the field of motion picture or television industry. And the standards for the people in the arts field is a little bit lower than the standard for an O1A visa. And the standard for the O1B visa is that the person must have received a distinction. And this means that the person must have achieved a recognition that is substantially above that ordinarily encountered by the other people in the industry. So we see that the standard is a bit lower than the O1A standard. And the standard for the people in the motion picture and television industry is that these people have to show that they have achievement that is substantially above that of their peers. And the standard for the EB1A green card is the highest. It's higher than the O1A and it's higher than the O1B visas. And basically individuals who have extraordinary ability in the field of sciences, arts, education, business, or athletics. So all the people, all these people can qualify for the EB1A green card. And the standard is that the individual who is applying for the EB1A green card must be one of the small percentage of people who have arisen to the very top of their field, and the person has sustained a national or international acclaim, and the achievements have been recognized in the specific field. And for all of these three categories, so for the O1A visa, O1B visa, and the EB1A green card, you not only have to show that you meet the standard and you have already achieved all these achievements, but you will also have to show that you are coming to the US to continue working in the area of your extraordinary ability.
And what about family members, Michaela? Can they come, with you on any of these visas, and kind of what are they permitted to do in the US?
Yes, so family members can come with you for all of these. So for the if you're applying for an O1A, O1B visa, and also if you're applying for a green card, and the family members, this means your spouse and your children under the age of 21, and your children and your spouse can attend school. If you are here on an O1A or O1B visa, unfortunately, your spouse cannot work in the US. But if you are applying for the EB1A green card and the green card is approved, then the spouse will get green card as well, and then your spouse can work in the US.
Perfect, thank you. So let's move to talk a little bit more about the O1A specifically, and what types of evidence do you need to qualify for an O1A?
Yeah, so for the O1A visa, you will either have to show that you have received a major internationally recognized award, such as, for example, Nobel Prize, or another kind of like a well-known award like that. Or if you have not received this type of award, you will have to show that you have evidence of at least 3 of these following criteria. So let's go over these criteria in a little bit more detail. So the first type of evidence you can submit is evidence that you have received a nationally or internationally recognized prize or award. And so this will not be the Nobel Prize, because if it was the Nobel Prize, you would just kind of like submit evidence of that, and that alone could be sufficient. But this would be basically other types of prizes or awards that are not that well known. And what you would want to submit is evidence of the prize. So this would basically be like a photo or of the prize or award you have received. And then you would want to submit evidence that the organization or the association that granted you this award is kind of reputable in the industry. And this could be, for example, like evidence of a website of the organization or articles about the organization, or it could be a letter from the organization kind of explaining what they do. But you would want to show that the organization is kind of reputable in your specific industry. And if there are any past famous winners of this award or a prize, you could also submit evidence of that, just to again show that the prize or award you received is reputable in your industry. The second type of evidence you could submit is evidence that you are a member of kind of associations in your field, and these associations require that you have outstanding achievements. So For this, again, you would want to submit evidence that these organizations or associations you are a member of are kind of reputable in the industry, and you would want to submit kind of the criteria, what are their criteria for someone to become a member. So if some organization accepts kind of anyone, and anyone can become a member of this association or organization, then it will not be that helpful for a O1A application. But if the criteria kind of require that you have outstanding achievements in your field, and you must be kind of like one of the top people in your field, then it will be helpful for your O1A application to show that the membership in this association requires the outstanding achievements. You could also submit evidence, if there are any kind of other famous members of these organizations or associations, you could submit evidence of that. Yeah, this would be the second type of evidence you could submit. The third type of evidence you could submit for the O1A visa is published material in kind of professional or major publications about you and the work that you do. And so for this, you would basically be submitting the media articles, and you would be submitting circulation statistics about the media that show that how many people kind of read these particular media outlet. And I would say that the more prestigious the media outlet is, the more helpful it will be for your application. So let's say that there was an article about you and your achievements published in Forbes or kind of New York Times. That would be very helpful for your application. If there was an article that was kind of published in a local media in your home country, and not that many people kind of read this particular media outlet, that would be kind of less helpful. You could still submit it, but kind of the more well-known the media outlet is, the more helpful it will be for your application. The other type of evidence you could submit is evidence of your original scientific, scholarly, or business-related contribution of major significance. So this would be, for example, if you kind of invented any patent or any kind of new process in your particular field, you would submit evidence of that. And then you would also want to submit evidence kind of explaining why this contribution is of major significance. And this would be, for example, media articles discussing this original contribution, or this could be also letters from some experts in your field discussing why this contribution has major significance. Another type of evidence would be authorship of scholarly articles in professional journals or other major media. So this would be, so for this type of evidence, you would again submit the evidence of the article and the circulation statistics of the particular media outlet. Another type of evidence would be evidence that you have high salary or other remuneration for your services. For this type of evidence, you could submit your W-2 or kind of equivalent of W-2 in your home country. And then you would also want to submit kind of statistics that show what is the average salary for this type of position in your field and for the geographic area where you are working. And you would want to show that your salary is kind of like much higher than the standard in the industry. The other type of evidence you could submit is evidence that you participated on a panel or individually as a judge of the work of others. So this could be if you were, for example, judging certain competitions, or if you have done a peer review for a scholarly journal, you could submit evidence of this. And if you were judging competitions, again, kind of the more prestigious the competition is, the more helpful it would be for your application. And you would want to submit kind of information about the competition, like what is this competition, like what kind of people participate in the competition, and just kind of more information that the competition is kind of very reputable in your particular industry. And the last type of evidence you could submit is evidence that you are employed or you were employed in the past in a critical or essential capacity for organizations that have distinguished reputation. So for this type of evidence, we usually submit letters from your previous employers that kind of explain what you were kind of doing for this company, that explain how was your role for the company's critical or essential, and that also explain why these previous employers, why these previous companies have distinguished reputation.
And Michaela, what if it's someone in an industry that's really not kind of traditional where you would see this kind of evidence? Like, is there anything that you can do if kind of some of these boxes really wouldn't apply to you? Like you're not in an industry that does authorship of scholarly articles or, really doesn't have kind of judging competitions. Like what can you do in that instance?
Yes, so so the regulations say that you can submit kind of another comparable evidence. So let's say that these or kind of like most of these criteria don't apply to your profession. You could submit other comparable evidence to show that you are still kind of like one of the small percentage of people in your field.
Perfect, thank you.
Mm-hmm.
So let's talk about the O1B and what types of evidence, and in particular, kind of what are this like? Is there a different standard of evidence for the O1B? If you have kind of a choice, sometimes there's categories that don't neatly fall in one or the other. Which would you recommend choosing?
Yeah, so the standard for the O1B is lower. So the standard for the O1A is that you must be kind of like in the top of your profession, like one of the small percentage of the people in your profession. The standard for the O1B is lower, and you have to show that you have distinguished and you are kind of substantially above kind of like the ordinary peers in your industry, and you are kind of well-known, prominent kind of figure in your industry. So the standard for the O1B is lower. So I would say that kind of if you could choose, or if your profession could kind of fall under both the O1A, O1B, the O1B standard would be easier to meet. And with regards to evidence, again, you could show that you were either nominated or you received a significant kind of national or international award. So this could be, for example, because the O1B is mostly for people in the arts. So let's say that you are an actor and you received an Emmy or Grammy. That alone could be sufficient for you to qualify for the O1B. So if you won kind of this type of award, that alone could be sufficient. If you didn't, then you would again need to submit evidence that you meet at least 3 of these following criteria, and they are a little bit similar than the O1A criteria. So I'll just go over them faster. So the first one would be evidence that you have been or you will be performing kind of lead or starring role in productions or events that have distinguished reputation. So this would be, for example, let's say that you are kind of an architect. We would want to submit evidence that you worked on some kind of distinguished, well-known projects, and you had either a lead or starring role in these projects. And this could be evidence, for example, by press releases, so media articles. It could be supported by letters from your previous employers, but that would be kind of like the first type of evidence or the first type of criteria you could meet. The second one would be evidence of that there is a published material about you and your achievements. So this would be, for example, if there are media articles about you and your projects in, if we kind of take the the first hypothetical again, if there are articles in like Architectural Digest or similar magazine about you and your projects, we would want to submit those articles. And again, we would want to submit circulation statistics about those media outlets, showing that kind of they're reputable in your industry and many people read these media outlets. The third type of evidence you could submit is evidence that you have or had a lead, starring, or critical role for organizations with distinguished reputations. For this type of evidence, we usually submit letters from your previous employers that kind of, again, go over why the organization you previously worked for has distinguished reputation, and how was your role for the organization lead, starring, or critical. Another type of evidence you could submit is evidence of major commercial or critically acclaimed success. This would be shown by box office receipts or records, or for example, by sales. So this would be applicable mostly for, let's say, for example, like singers or bands, or performers, for performers. Another type of evidence you could submit is evidence of significant recognitions for achievements from organizations, government agencies, or other experts in the field. So these are so-called expert letters, and we'll be discussing these in more detail later in the presentation. But basically, for this criteria, you would want to submit about like 4 or 5 letters from certain experts in your industry that discuss your kind of accomplishments in the particular industry. The next type of evidence you could submit is evidence that you commanded a high salary or other high remuneration for services in the industry. So for this, it would be the same type of evidence as I already discussed for the O1A. So it would be, for example, a W-2 or kind of equivalent of W-2 in your home country. And you would again want to show what's kind of like the average salary for your position in the particular geographic area where you are located. And you would want to show that your salary is kind of substantially higher than that. And for the O1B, you could also submit if kind of like none of these criteria apply, or if only some of them apply. You could also submit other comparable evidence to show that you still qualify for the O1B visa. But the other comparable evidence would only be available for people who are applying for the O1B in the category of arts, and it would not be available for those that are applying in the category of the motion picture industry. Perfect. So now we can.
So for the EB1A, I know you're going to talk about kind of some of the requirements and the similarities, but, you know, one thing that's you always see when you look into extraordinary ability, green cards, or visas is mention of the Kazarian analysis. So can you describe a little bit about what that is and why it's so important for these types of visas?
Yeah, so the Kazarian analysis is very important for the EB1A green card. And basically, when USCIS is adjudicating the EB1A green cards, it goes through 2-step analysis. So in step 1, and I'll just quickly mention that the criteria for the EB1A green card are very similar to the O1A and O1B visa. So I will not go over them in detail, but you would again need to show that you either won kind of like internationally recognized award, or you meet 3 of the 10 criteria. And the Kazarian analysis is as follows. So in the step 1, USCIS will kind of look at the evidence, and they will look whether you either have kind of like that one-time achievement and one-time award, or if you don't, they will look at whether you meet at least 3 of the 10 criteria. And if you do, that's great, and they will move to the second step. But just because you meet 3 of the 10 criteria, doesn't mean that you kind of automatically qualify for the EB1A green card. So if you didn't submit evidence that you meet 3 of the 10 criteria, the petition will be denied because you just didn't submit sufficient evidence. If you did submit evidence showing that you meet at least 3 of the 10 criteria, then they will move to the second step of the analysis. And in the second step, USCIS will consider the quality of the evidence you submitted. And they will be really looking at the evidence, and they will be looking whether you are really kind of like one of the small percentage of people who have arisen to the very top of your field. So let's explain this Kazarian analysis on an example. So let's say that you are, for example, a wedding photographer, and you were invited to judge a certain competition. So in the second step of the analysis, USCIS will look at things like how many other photographers were invited to judge this competition. Was it like 3 more people, or was it 50 more people? Then they will look at who is organizing this competition. Is it some reputable organization or association, or is it some kind of like really small association that is just kind of starting? They will look at who are the participants in the competition. Are they kind of like people who are just starting their career, or are there other kind of like well-known photographers? And they will also look at the organization's standards in selecting the judges. So, do they select judges? Do they kind of invite like anyone to judge this competition, or do they really require the judges to be kind of like one in the top of their field? So they will kind of like look at all these things to make a kind of like a final decision, and look at the quality of each evidence to make a decision whether you are really one of the small percentage of people who qualify for a green card for the EB1A green card. So that's basically the EB1, the Kazarian analysis for the EB1A green card.
And do you have to kind of have the O1 first before you can apply for the EB1A? Is it like a step process?
So no, I would say that most people do first have the O1A or O1B. They are in the US for a couple of years, and then they apply for the EB1A green card, but it's not required. So let's say that you, for example, lived in your home country your whole life, and you decide you want to you don't want the O1A or O1B visa first, you just want to go immediately for a green card. That's possible, and as long as you meet the standard, you could apply for the green card immediately.
And, in a lot of these green card processes, you have to show that there's no one in the US that can actually do what you're doing. Is that part of the EB1A at all?
No, so this is not required for EB1A, just because the EB1A is really for kind of like the very top people in the industry, and kind of like the idea behind it is that US wants to kind of like all these like top people in the industries to come to the US, so they kind of like skip this requirement for the EB1A green card.
Perfect. All right, so let's move to talk a bit about, the most important differences between the O1A and the O1B, and then what are the similarities that are important to note as well?
Yeah, so I would say that the main difference is, the kind of like the field. So if you are working in the field of science, education, business, or athletics, you could only apply for the O1A visa. And if you are working in the field of arts, or a motion picture or television industry, then you could only apply for the O1B visa. But like all these people who work in all these fields could apply for the EB1A green card. So the EB1A green card doesn't kind of have this, it's applicable for all the people, but I would say the first difference is like what field are you working in? Then the second biggest difference is the standard. So as we mentioned, the standard for the O1A visa is higher. So you will have to show that you are one of the small percentage of people who have arisen to the very top of the field. And the standard for the O1B is a little bit lower. So the standard for people in the field of arts is that you must show that you have a high level of achievement, as evidenced by degree of skill and recognition substantially above that ordinarily encountered. And the standard for a motion picture and television is that you must have achieved a level of acclaim substantially above those of that of your peers. With regards to some similarities, so the both of the visas can be issued for the same period of time. So the initial visa can be issued for up to 3 years, and then it can be extended for anyone from 1 to 3 years, kind of depending on your projects and what kind of projects you'll be doing in the US. And another similarity is that for both type of visas, your family, as we mentioned, can come to the US. So your spouse and your children, unmarried children under the age of 21, can come to the US, can study in the US, but your spouse, unfortunately, cannot work in the US if you are here on the O1A or O1B visa. Perfect. Yeah, so let's move and let's discuss the national interest waiver visa now. So Kelly, what are the threshold requirements for the NIW visa?
Right. So for the threshold requirements, you have to show that you have either an advanced degree or its equivalent, or you have to show that you have exceptional ability in the sciences, arts, or business. So when we say threshold requirements, we mean this is kind of the minimum standard of what you need to have before you can even consider, should I try for the national interest waiver with my proposed endeavor. If you don't meet these requirements, then you're not going to be eligible. When we look at exceptional ability, you have to, it's similar to the O1A and O1B and the EB1A in the sense that you have to meet 3 out of 7 criteria. But it is also important to note that exceptional ability is a slightly lower standard than extraordinary ability. So that's something to consider if you're someone who's very accomplished in your field, but you don't feel you necessarily meet that standard of having risen to the very, very top. Then you can kind of show exceptional ability, using 3 of the 7 criteria, things like letters documenting 10 years of full-time experience, evidence of a high salary, recognition for achievements. And this standard is also viewed in the same way, that Michaela described with the Kazarian analysis, in that you couldn't just show, here's letters showing 10 years of full-time experience in my industry. Those letters need to indicate, when you look at that holistically, that you really were, rising above what is kind of the average or even, good or great work in your field. It really needs to be kind of just an elevated level in terms of what the letters are describing about your work history. And that's the same for all of these criteria when you're looking at which ones might you want to use to meet exceptional ability. If you have, an advanced degree, then you don't need to actually do that. You can qualify either using your advanced degree or an equivalent of advanced degree, which would be a bachelor's degree plus 5 years of post-baccalaureate progressive work experience. And that is very important because we do have clients that will come to us sometimes and say, well, I'm really experienced in my field. I got a master's late in life, and I got a bachelor's late in life. And unfortunately, you do need that. It does need to be kind of post-baccalaureate in order to count if you don't have that advanced degree. So once you show that you've met that threshold requirement, then you move on to show that you actually qualify for the national interest waiver. So to actually qualify for the national interest waiver, you need to meet these 3 additional criteria. So the first is you need to show that your endeavor has substantial merit and national importance. You're well positioned to advance that endeavor. And then on balance, it's beneficial to the US to waive this normal requirement of the job offer and labor certification. So the normal requirement where you need an employer to sponsor you, they have to test the labor market for US workers. All of that is, skipped over in the national interest waiver. And let's look at each of these criteria in a little more detail. Proving that that the proposed endeavor has substantial merit and national importance, it's good to remember this can really be an appropriate visa for a wide variety of fields. Things like business, health, education, technology, science, culture, and entrepreneurialism, are all kind of flagged as important industries. There could be others. Any endeavors that kind of further human knowledge in really key areas that have national importance, like medical advances, changes in kind of military technology, any kind of like civil engineering. Also, anything that produces a strong economic impact, on the United States that could be found to have substantial merit and national importance. When you're looking at national importance, the government is often going to look at what is the potential future impact, how is that important to the US? Oftentimes, governments will issue kind of annual reports in various industries outlining why specific areas are really key. And those can be really helpful when you're documenting your case to include in your supporting documents.
Kelly, quick question. Can entrepreneurs qualify for the national interest waiver? And could you give like an example of a case where this was successful?
Sure. So yes, they can. Entrepreneurs can qualify for the national interest waiver. And it's something that over the past, maybe few years, maybe 5 years, has really become a much more friendly green card option for entrepreneurs. There's specific things we'll kind of talk about in future slides, changes to kind of the legal standard, but then also changes actually even to the USCIS policy manual that specifically were made with an eye towards, making this category more friendly for entrepreneurs. In terms of kind of a case example, there's one person that comes to mind who was starting up a technology consulting company whose focus was on helping small and mid-sized businesses to utilize and integrate the newest technologies without worker displacement. So, and this person had developed a specific patent, that was, kind of aimed towards that. So a big concern kind of with growing technology is that there will be worker displacement, there will be job loss. There's been lots of articles in major media and other types of industry reports about this. And so this particular endeavor was found to have substantial merit and national importance because it was dealing with something like this, this worker displacement issue, and had a particular technological solution to this issue and then it had a business plan kind of backing up that they would be able to move this kind of venture forward. So then when we look at well positioned to advance the proposed endeavor, this person had 35 years of experience in their particular field. This was documented by, letters from, former colleagues, former supervisors, attesting to their excellence in this particular field and what they were able to bring. Additionally, the person was able to provide letters, from people and experts in the field and also companies that were interested in working with this person, to have them help their companies, and then also kind of larger companies, that were interested in working with them on this technology as well. So those were all really key in showing that this person was well positioned to advance the endeavor. And then in terms of showing on balance, it's beneficial to the US to waive the requirements of a job offer and labor certification. For entrepreneurs, one thing that you can argue is that because the person is an owner of the company, if they are an owner, and particularly if they're a majority owner or 100% owner, the EB2 labor certification process is not set up for them. They will not ever get through that process. It's impossible, to go through that process as a 100% owner of a company and do it successfully. So that's kind of one argument to use. You can also argue that even if there are other people in the US doing this work, the issue of worker displacement is sufficiently urgent that it's, it doesn't hurt the United States to have multiple people working on this issue. And you can also argue that the person themselves are kind of so exceptional, so, well positioned to advance the endeavor that, it merits waiving the labor certification. So in that particular instance, an entrepreneur was approved, for the national interest waiver on that set of facts.
Okay, thank you. And Kelly, one other question: how long does it, on average, take to get the green card through the national interest waiver?
So it can take quite a while. It depends. Right now, they're in a process where they're kind of phasing in premium processing for the national interest waiver. So once that fully takes effect, that will be great, because once premium processing is phased in for all of national interest waivers, you can pay the government an additional fee, and they'll adjudicate the case within 45 business days. I think it's 45 business days. It may be 45 calendar days. They're changing it right now, but right now for cases that were filed, I think prior to August 1st, 2021, there's an ability to file for premium processing. Once the case was approved, then you can kind of move forward. If you're in the United States in a valid status, you could file an adjustment of status based on the approved I-140. If you are living abroad, the I-140 approval would go to a consulate. The process to get the green card at a consulate or through adjustment of status in the U.S. can take, several months, including up to and over a year right now. It really depends on how kind of backlogged the specific field office is. We're seeing, something from kind of like 10 months to a year for employment-based adjustments at a lot of field offices. At consulates, it just really depends on kind of how backlogged they are and how well they've recovered from COVID, because that's still really an ongoing issue. So, but for most people, let's say you were getting ready to file your petition today, you have to be ready that it could take, a few years to actually get the approval. We do hope that they will expand premium processing as they've said they're going to do, but at this particular point in time, that's not available for new applicants of national interest waivers. So it could take, you need to be prepared that it could be a few years. Perfect. So let us move to talking about expert opinion letters.
Yeah, Kelly, so what is the purpose of the expert opinion letters for the national interest waiver, and how many of them usually have to get, and from what type of experts?
Sure. So the purpose for a national interest waiver is really twofold. One is that the letters need to speak to kind of the substantial merit and national importance of the proposed endeavor. And then the other is letters that are speaking to kind of the applicant's contributions in the field. How are they well positioned to advance the endeavor? You may have letters that kind of touch on both. There may be people that are experts in your industry that are able to speak to kind of your particular expertise and experience, and also reflect, the substantial merit and national importance of the proposed endeavor. You may have expert letters that kind of only deal with kind of one or the other. One thing that can happen for national interest waivers is you may even get kind of an economist who can write particularly for entrepreneurs, if you can have an economist that's going to write a report on kind of the economic impact, direct and indirect job creation, all of that can be very helpful, in building your case for kind of, substantial merit and national importance. In terms of kind of, the letters that are more about you, you want to think about kind of the letter should include a description of the expert's relationship to you, a description of the experts, why are they an expert? Why should their thoughts be taken into account? You want them also to include kind of a description of your professional history and impressive contributions to the field. Even if they know you through one certain area, it's often good to get them to, look at your resume, have a conversation, and kind of include some of the other even if they spoke with you at one particular conference, it would be good for the letters to mention, that you have spoken at, 50 conferences. So you want to have that, anything about your impressive contributions that they can reflect back in the letters is generally helpful. Any prizes you've won, awards, any influential publications, any particular business success you've had, if you've spoken on prestigious panels, if you have done any kind of groundbreaking research or done anything that has impacted it on an industry-wide level where they, took into account kind of something that you did and now it's an industry practice. Those things are particularly compelling and are good to be outlined in the letters. So, you want to think about as listed on the slide, who's writing the letter. Some of them may be people that kind of know you, that you've worked with, your former supervisors, past employers. Some may be kind of people that more peripherally, through just being an expert in the industry. And those, I think it's really helpful to have a mix because, it's nice when you can have somebody who doesn't really know you, but just knows you through your work, who can write and kind of confirm that you are an industry expert and able to move forward with this endeavor. And then it's also good to just remember when you're thinking about these letters, whether it's for an NIW or whether it's for an EB1A, these are not meant to be just kind of recommendation letters, like somebody who says, yes, I worked with this person, they were great. This is really meant to be, it's really meant to kind of highlight, that you've reached this extremely high standard, or that your endeavor is in this, area of substantial merit and national importance, and that it's really, you're well positioned to advance it. I'd say the main, kind of difference between the NIW expert letters and the EB1A expert letters is going to be that the EB1A are really just going to focus on you. It's only about you. If the, it's really just about your accomplishments, how do you meet those criteria? Whereas the NIW letters also need to take into account a description kind of generally of what is the endeavor, why does it have substantial merit, why does it have national importance? Okay, so looking at which category to apply for, out here. So, when you're thinking about which category to apply for, you want to figure out whether or not you want to stay in the U.S. temporarily or permanently. So, the O1A, the O1B, those are, let's say you have a job offer in the US, you want to come and work in the United States in your area of extraordinary ability, but, you're going to travel in and out. You don't really have any intention to stay in the United States long term. At that point, an O1A or an O1B is going to really be the best visa for you. As you have new work, you can kind of continue to either renew the visa or get new visas as you need them. And doesn't just allows you to travel in and out, allows you to have that work authorization, but really doesn't go beyond that. If you're someone who has been here in the US a long time and you want to live here permanently, or you're looking for a permanent solution, or you're outside the United States, but you've always wanted to live here permanently, that's when you want to be looking at the EB1A and the NIW. Those are the green card categories for people that want to live in the US permanently. Other things to consider when you're looking at the category to apply for, do you have a U.S. employer or agent, or do you want to self-petition? So if you're outside the U.S., you have a very impressive background, but you don't have an employer and you don't want one, maybe even you want to kind of come and do the work that you want to do in the U.S., that's when the EB1A and NIW are helpful because they allow you to self-petition. The O1A and the O1B do require a U.S. employer or a U.S. agent who's going to sponsor you. So it's not possible to self-petition for the O1A and O1B the way it is for the EB1A and the NIW.
And Kelly, if someone owns a company in the US and wants to apply for the O1 visa, would that be possible that the company would sponsor the person for the O1 visa?
So yes, that is possible. It is possible that as an O1, you own your own company and your company is considered a separate entity from you and can sponsor you. There can sometimes be pushback. USCIS is, we've done it successfully. Many people I know have done it successfully. I think there's lots of support for it in the regulations. There's even specific support in the Foreign Affairs Manual that specifically says somebody O1s cannot self-petition, but a company, a corporate entity is separate from an individual and therefore can petition. That being said, there can sometimes be pushback. So you do want to have the discussions with your immigration attorney to determine how do I best structure this, to make sure that it goes through. And then just, when you're talking about family considerations, another thing that I think is always important to talk about is just, what do you want to do with your family? Does your family want to come with you? Do they want to work? As Michaela mentioned, for the O1A and the O1B, spouses and children under 21 can come, spouses and children can study, but they cannot work. If everyone in the family wants to kind of be there long term, spouses and children under 21 can apply with you when you apply for your green card. If you think that your family may want to live in the United States, long term, it can be helpful to just kind of do that planning ahead of time so that you're not in a situation where your children are aging out and needing to find their own status in the US. So if you are pretty confident you want to kind of stay long term and you have children, who are on the younger side, it can be good to kind of create a plan now so that you are not kind of dealing with it when your child's getting close to 21.
And Kelly, we kind of discussed this for the EB1A, but do you have to have an O1 before applying for the NIW? And is it common that people first have the O1 and then they apply for the NIW? Or is it common that people just kind of apply for the NIW immediately?
So I'd say so similar to the EB1A, you don't have to have any particular visa before you apply for the NIW. I think that it is often the case that people that apply for the NIW are here in the US working in some capacity. Most of the time, I think that is the normal path is that people are here and then they want to be here more permanently. It may be the case that someone is completely outside the US and has an endeavor that they think is important that they want to bring to the US, but I think that's less common. Most of the time that people do have, some type of underlying status in the US where they've been working and that they want to kind of advance that through the NIW. But certainly an O1 is not required. No kind of underlying non-immigrant status is required to file for the national interest waiver. You can file from it whether you're in the US or whether you're outside the United States.
Thank you.
Perfect. So looking at considerations when moving from a non-immigrant visa to a green card. So, one thing is just being granted an O1 does not automatically qualify you for an EB1A. Many people, in the same way that people kind of believe that it may be required to get an O1A first and then get the EB1A, it can often be a perception that if you have the O1A, you're automatically, easily on the track for the EB1A. I think especially when, for people on O1Bs, where the requirement is distinction in the field, so it's an even lower requirement than the O1A, and the O1A requirement is an even lower requirement than the EB1A. An O1B to an EB1A can be kind of a big leap. So because the O1B standard is significantly lower than the EB1A standard of sustained national or international acclaim. So something important when you're doing your planning is you want to, if you're on an O1B and perhaps you got it based on distinction in your field, you want to continue to work on your portfolio. You want to continue to really build up, the work that you're doing, knowing what the EB1A criteria are, you can have an eye towards, getting your work published, like, pushing for kind of information about you in major media, attempting to publish scholarly articles, really pushing for any contributions that you make, to really be kind of memorialized in a way that you can submit that to the government to say, here, I actually do meet the standard. So it may be that somebody who came in and qualified for the O1B, and then had that for 3 years, has really built up their profile, and now they're a great EB1A candidate. But you can't just assume that because you have, an extraordinary ability non-immigrant visa, that you'll automatically get, the green card in that category. I think another consideration is timing. So if you're on a non-immigrant visa, like a TN visa, where doesn't allow for non-immigrant intent, if you file an I-140, that could prevent you from renewing your TN visa. When you go to the border or the consulate and they see that you have an immigrant petition pending, they may say, we don't think you qualify anymore. So you want to just consider, what is my underlying visa? What is the timing around when I want to file my green card petition versus when my non-immigrant visa ends? If you're on a visa like an O1, that language is a bit more permissive in terms of filing the immigrant petition and then being able to extend. Just having an I-140 petition filed isn't a basis for denying any approvals of a new O1. But it is still a factor to consider, because it is something that could come up either at a visa interview or at the border. And then the final thing to consider that we talked about a bit in the previous slide is just, do you have children that also want the green card? And if so, file early to avoid those issues with the children aging out. All right. So, kind of the last slide before we get to the question section, kind of extraordinary ability categories and their availability for entrepreneurs.
Yeah, Kelly, so can you talk more about how entrepreneurs can use the extraordinary ability categories and which of them they can use?
Sure, of course. So, extraordinary ability categories available for entrepreneurs. We've talked a bit about, the O1A, that's a potential. It does have a bit of a wrinkle in that if you're owning the company 100%, there's definitely authority that says you can still file, the company can file on your behalf, but it can be a bit more, a bit more challenging depending on, how USCIS is treating those cases at that particular time. For entrepreneurs, the EB1A and the national interest waiver are both really good categories because both have the ability to self-petition, which is something that I think entrepreneurs often, that's really what they need, is that ability to petition for themselves, so that they can either run their company or maybe they have multiple kind of entrepreneurial endeavors. In particular, though, even though either one, the EB1A or the NIW, is available, the NIW, I think, is generally an easier category for entrepreneurs. There were changes in the NIW standard under the case matter of Danazar. This made it a much friendlier category for entrepreneurs. There was specific language in that case that made it clear that they meant for it to be friendlier to entrepreneurs. And then additionally, even, in the past year, U.S. Citizenship and Immigration Services updated their policy manual to provide additional guidance on the type of evidence that's going to be helpful for entrepreneurs. So, that guidance tells adjudicators, please take into account that entrepreneurs don't have traditional career paths. There's no particular way this endeavor needs to be set up. So they're trying to, I think, build in some flexibility in how USCIS looks at these petitions for entrepreneurs. Additionally, they even added some types of evidence that should be considered in the NIW category, I think, that are very, friendly for entrepreneurs. So evidence of, having investments from outside investors, that are consistent with industry standards can show substantial merit, because now you have these outside investors that think this business plan, is a worthy undertaking. Similarly, if there's any participation in incubators or accelerators, that's something you really often see with a lot of startups. Any kind of awards or grants from government entities, particularly those well-versed in economic development or job creation, can be really helpful. Any kind of proof that the entrepreneur has a history of, revenue growth in their undertakings, job creation, as well, even kind of letters from third-party reviewers. Let's say you have a product, you have some technology, it's going through beta testing, or it's being sent out to retailers, and they have positive feedback. All of those things kind of were added to the policy manual that could be taken into account for NIWs. So I think that ultimately, while O1A, EB1A, or NIW is open to entrepreneurs, I think NIW, if you're interested in the green card, can be a really good option for entrepreneurs if you have some of these elements that we've been talking about during the presentation. All right. All right, so we've, I think reached the end of the presentation. It doesn't look like we have any questions. So I will close out here. Thank you so much to everyone for, for joining us today. Michaela, thank you for sharing your knowledge with us, and I hope everyone has a great day. Thank you.
Thank you.